All right. Yeah, I can hear you. Can you hear me?
Okay. Yes, I can hear you. Thank you. Mr. Epperson, have you heard my comments about, the fact that I am an attorney with, well, it doesn't matter in this one. Mr. Epperson, are you represented by an attorney?
I have gotten advice from attorneys, but I am acting in pro se.
Okay. All right. So where are we on this one?
Well, Your Honor, there was a trial date set for May 24th. Mr. Epperson and I have had some discussions. He contacted me before today's hearing and I was not able to get back to him. We're working on a resolution. I've made an offer and Mr. Epperson has declined, which is his right, and has elected to proceed to trial with this matter, which is where we are currently still headed.
Okay. And that would be May the 18th. Is that what you said?
I had May 24th as a trial date, but
Oh, okay. Well, that would be a non-jury trial. Was there a waiver of jury?
no, I don't believe so. I believe the intent was to have a jury trial.
Yeah, it's May 18th on the notice. Okay, Mr. Epperson, your trial date is May 18th. Trial commences.
If I may, I would ask the court to amend the previous judge's ruling to extend due process. I did not waive my right to due process, and I'm asking that because the prosecution and the police responded to this incident and saw the video, which is the only evidence in this crime, and they failed to procure that evidence, and it had no bearing on whether COVID was present or not. They could have secured the video and they did not. So there are reasons to extend the trial for due process and waive my right to due process. For that excuse is, I mean, the point is mute.
All right, let me take a second to read the file. Hold on a second. Okay, I'm not seeing any written order. Mr. Rhodes, can you fill in any gaps on this?
I think I can, Your Honor. Mr. Epperson is addressing two different and unrelated questions and issues here. Judge Bates found good cause to extend speedy trial out of the practical consideration that a trial could not be set in sooner than May 18th. And he addressed that on the record orally. The other question is an evidentiary discovery issue regarding an alleged video that may have existed but was erased before the law enforcement officers could secure it.
Sir,
Hold on, don't interrupt, Mr. Epperson. Hold on, you'll get a chance to talk. Go ahead.
Mr. Epperson takes issue with that fact and may have arguments at trial concerning the evidentiary ramifications of that failure to secure the video, but continuing this matter to a date beyond the 90 days was based upon the ability of the court to set this any sooner than May 18th, and Judge Bates addressed that on the record. It had nothing to do with the evidentiary questions or issues in this matter.
All right, any response, Mr. Epperson?
Mr. Rhodes is well aware that the officer's statements indicate that the video was reviewed, and so him playing it off like there may have been a video, he didn't know. He knows dang well that there is a video, and he did not secure it. And I requested discovery, and I sent a certified letter more than 2 weeks ago to secure all evidence, including that video. And so this chauvinistic attempt to proceed through this case is just that. It's chauvinistic, just to procure funds for the city of Montesano in his deal of the amount of $300, and to have some type of other control over me as a person. And if I break the law, he knows that there's a video, and the fact that he's acting like there may or may not have been a video just goes to show that he's not very familiar with the case, or he's just downplaying it because you have not been present in the previous hearings. So, I mean, this is pretty ridiculous.
Okay, Mr. Epperson, I don't see a motion with regard to the videotape, the existence or non-existence of it. I will not change Judge Bates' decision with regard to setting the matter for May 18th. The matter will continue to be set for May 18th. That will be your jury trial day. If you have a motion with regard to evidence, the availability of evidence, you need to file a written motion in advance of the trial that lets me know, or whoever is the judge sitting at your trial, what the basis of that is. That's where you'll get a chance to tell your side of the story. All I have in the file is a pleading innocence statement. I don't see a motion.
If you can see this is it's blurred out, but this is the motion. I sent it to the court as well as Mr. Rhodes.
Okay. What day did you send it? What day did you send it?
The date I sent it was approximately January, sometime in January.
I have a document called pleading innocent. Is that what your document is called?
No, it says motion for discovery of information necessary to receive a fair trial. Comes now, Nicholas Epperson, pro se, and respectfully moves this court pursuant to the 6th, 8th, and 14th Amendments of the United States Constitution to require prosecution to disclose to myself, the defendant, and permit us to inspect, copy, and test the photograph of the following. Would you like to listen to the rest of the?
No, I have it right in front of me, but it is not a motion with regard to due process or some allegation of wrongdoing on the part of the city. This is simply a discovery document. You're asking for it. Now you have to take the next step if you're going to try to get your case dismissed by moving on based on not having received it. This is why you want it dismissed. You got to put that in writing and give Mr. Rhodes an opportunity to respond to it. So the case will remain set for May 18th. In my other courts, what I require is that the defendant come again for a pretrial, the most closest to the jury trial. So you'll have to come back on April the 26th. April the 26th will be your next pretrial. And do I have a proper address if it includes 234th Place?
Yep.
Okay. All right. So case will remain set for trial with a pretrial on April 26th. That would be a good day for you to have filed your motion.
Okay.
Prior to that date. Okay.
So I'm just trying to figure out how I can give you the context for any of these motions you're requesting. I mean,
I can't give you advice, but the normal way lawyers and people who are representing themselves do it is they prepare a document called a motion. And in that motion, they say exactly what they want to have done. And then adjoining that, either in the form of an affidavit or a declaration, is a narrative that explains the facts that they believe they can prove, and the law as it applies to those facts. That's what's needed.
Okay,
Okay?
thank you.
Thank you. All right. Are there any others ready to go?